Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. If you've been watching this channel, you've probably seen the videos about GWACS Armory and their lawsuits with KE Arms, Russell Fagan, Sinistral Shooting Technologies, Brownells, and Sean Nealon. And if you haven't, well, to try to get you up to speed really quickly, GWACS Armory is suing lots of people and there's some lawsuits back and forth, all centered around this issue with respect to some monolithic polymer lowers. GWACS Armory is saying that their intellectual property was being infringed, that there were violations of NDAs and various other things. The problem is that they've actually been really bad at having intellectual property, which is normally considered a requirement in order to sue people for breaching your intellectual property. It's kind of otherwise like alleging somebody stole your imaginary car or your air guitar. So yeah, I've been a little critical, and that's going to continue. So today we're going to go and review in some detail. We're going to do a deep dive into motions for summary judgment. And summary judgment basically means that they're asking the court to throw out various claims here because they're saying that they simply cannot be sustained. There's not enough evidence that a jury should even be allowed to consider them. Now, everybody's got claims here. There's motions all around. So we're going to dive right in here. Pour yourself a drink because there's going to be some snark. And let's have a look. All right. So as mentioned, here's the lawsuit, GWACS Armory, various other people. We're going to skip on through to opinion and order. I'm going to skip over as much of this as we can just for brevity, but I'm going to make sure that we cover all of the stuff that's kind of relevant. A lot of it's going to be, we're going to do a lot of kind of going over stuff that was alleged in previous issues. The thing is that now these will be findings of the court. So we're going from stuff that was previously alleged in various filings to now what the court is deciding. So opinion and order. Now before the court are the following motions. Plaintiff's motion for order dismissing claims against defendant Sean Nealon with prejudice. What that means is that GWACS Armory wants to cut Sean Nealon out of the case. And he's actually fighting that because he's saying, whoa, 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 you don't get to cut me loose until you pay my lawyer's costs. That's going to be the issue on that one. Defendant KE Arms LLC's motion for summary judgment. Defendant Brownells Incorporated motion for summary judgment. Defendant Sean Nealon's motion for summary judgment. Russell Fagan and Sinistral Shooting Technologies motions for summary judgment. Counterclaim defendant motion for summary judgment and brief in support. And defendant's motion for spoliation sanctions. So we're dealing with a whole lot of different motions today. This is basically a major sort of cross-reference or big kerfuffle here. So plaintiff GWACS Armory argues that its communications with defendants KE Arms and Brownells were privileged, and they seek summary judgment on KE Arms counterclaims. So everybody wants all the claims against them thrown out. GWACS also seeks leave to dismiss its claims against Sean Nealon with prejudice to refiling. And what dismissal with prejudice to refiling means is that it's over, it's dead. Without prejudice would mean that they could just refile it later if they felt like it. But dismissal with prejudice means they're not going to be able to do that. It's over, it's gone. They're saying we're not coming back. So each defendant seeks summary judgment on GWACS claims against them. Defendants argue that GWACS did not disclose to defendants any information pursuant to non-disclosure agreements that was proprietary or confidential, and defendants request summary judgment on GWACS breach of contract claims. Defendants also argue that GWACS does not possess any intellectual property or trade secrets, and they assert that they cannot be held liable for misappropriation of intellectual property or trade secrets. Remember how I said that GWACS appeared to be being really bad at actually having intellectual property? Well, now we're seeing that here. So, cheers. All right. So we're going to skip over some of this here, but the basic background, Sean Nealon formed a company called Cavalry Arms Corporation, and their main product was a semi-auto rifle called the Cav 15. That was designed by Nealon and other employees of Cavalry, including Russell Fagan. and Fagan subsequently became the vice president of cavalry. And so one of the big things on that one was that it was a polymer receiver instead of steel or aluminum, which made it lighter. And another feature is that it was monolithic, meaning that it was just one piece. Everything fits together. So the stock, the grip, the magazine, all of that is one bit. And yeah, they note that much of the information related to the design and manufacturing of the CAV-15 was published on Cavalry's website or otherwise disclosed to customers because customers expressed concern about the use of a polymer in manufacturing components for a rifle. So essentially, people out there who might buy a gun were going, you want to make this gun out of plastic? Are you sure? And they said, listen, this is, we know what we're doing. Here's all the details. Here's all the specs. Here's all the diagrams and all of that, because they were trying to reassure the public. This is going to be important when we get to claims of trade secret protection, because you can't own a trade secret in something that has been disclosed to the public. Trade secrets, by their definition, have to be secrets. So, yeah. Already we got some interesting things going on to start, and this is way back ancient history before anybody thought of suing anybody. So the CAV-15 lower polymer receiver was later renamed the Mark I, and Cavalry developed an improved version marketed as the Mark II. Cavalry later produced a prototype for a lower polymer receiver known as the Mark III, but Cavalry never manufactured or produced the Mark III for distribution, so it was just an idea. Cavalry did not obtain a patent, trademark, or copyright for the Mark I, Mark II, or Mark III. So all of the things that we would normally consider as intellectual property, they had none of them. This is going to be important because as much as Cavalry's not involved in this, they are the origin point for all of this. On March 3rd, 2010, Cavalry and Sinistral Shooting Technologies entered into an asset purchase agreement for the sale of the following assets. So Sinistral Shooting Technologies is buying a bunch of stuff from Cavalry. That includes 1 CAV-15 Mark II cores and cavities, 1 CAV-15 Mark I cores and cavities, 1 CAV-15 mold base, 1 CAV-15 linear vibration welding resin base fixtures. I'm not going to pretend that I know much about linear vibration welding, but they're buying one. All of Seller's CAV-15 drilling fixtures, all CAV-15 specific hand tools, all CAV-15 specific nuts, bolts, screws, roll pins, all CAV-15 front and rear pivot, takedown pins, all CAV-15 serial number tags. So bunch of other stuff you would use to assemble CAV-15s. All licenses for the above described assets to the extent they are assignable, including those set forth on Schedule 4.1, and all records required to be kept on the above described assets pursuant to parts, blah, blah, blah. So basically where they were required to have records because, firearm manufacturing is heavily regulated, those records were to be passed along. Cool. So that's a bunch of stuff. So SST was owned by Fagan at the time of the transaction, and Fagan states that he's currently the controlling member of SST. Also good. Cavalry agreed that it had title to the assets being sold, but Cavalry made no representation that it possessed any protected or exclusive intellectual property rights to the assets. Now this is important because you can have a distinction between a physical object and some of the rights behind it. And I'll just reach out here and grab an example. So, all right, so we've got here a copy of Neverwhere by Neil Gaiman. I own none of the intellectual property on this. I don't own the cover art. I don't own any of the writing. I don't own anything, but I do own the copy. So I can sell this copy to somebody if I want to. I could say, hey, Bob, you want to buy this? It's $2 or whatever. And Bob can buy this. But that doesn't mean that he owns the right to start printing more copies of Neverwhere. In fact, Neil Gaiman would probably hunt him down with a fire axe. Metaphorically, a legal fire axe. So that's kind of an important distinction here. So just because SST is buying these molds doesn't mean that there's any intellectual property associated with them whatsoever. All right. So SST and GWACS later entered into an asset purchase agreement for the sale of the following assets. So now SST is selling a bunch of stuff to GWACS. So one, a Vandon 300 Press HT series model 300 HT with Pathfinder 4500 controller. I don't know what this thing does at all, but one was sold. Conair plastic dryer with hopper. I can guess what that does. Branson 90 series linear vibration welder model VW2 serial number. I know that that's a linear vibration welder, but I don't really know beyond that. Takedown pin sets. That at least I understand. Serial number tags. Fairly self-explanatory. CAD drawings, design prints to the mold, including any and all intellectual property IP related thereto. Now, this is going to be key because GWACS says, hey, this means we thought we were getting a bunch of IP. But they can't because Sinistral never had any IP relating to those. So they can only get the IP that actually is owned by Sinistral, and there's nothing in that purchase agreement that actually has Sinistral representing that they own any intellectual property with respect to these things. It's just any IP that Sinistral happens to own for those things would get transferred, but that doesn't mean you can make something exist. So, takedown pin specifications, miscellaneous tools and equipment to manufacture, market, and sell the lowers. So, yeah, that's what was sold. So, now there's a bunch of sort of intervening time. Fagan later works for a competitor of GWACS, which is KE Arms, while KE Arms was marketing a lower receiver known as the KE-15. And the KE-15 was either forged or billet, with the billet version having a flared magazine. I've actually had the opportunity to shoot a KE-15, and I quite enjoyed it. On June 15th, 2015, KE Arms entered a mutual NDA with GWACS to allow the parties to evaluate the feasibility of a business relationship, and they anticipated exchanging trade secrets or proprietary information as part of this process. So they then set up a non-disclosure agreement between them, and they note, even if one party marked information as proprietary, the agreement states that proprietary information does not include information which, A, at the time of the disclosure was already in the possession of the receiving party, B, is independently made available to the receiving party by a third party not bound directly or indirectly by a non-disclosure obligation to the disclosing party, C, is in the public domain, or D, is independently developed by the receiving party without reference to proprietary information received from the disclosing party. Why would you include those exceptions? Well, because otherwise this non-disclosure agreement would basically be a suicide pact, because the other side could be like, hey, we're disclosing something proprietary, and that is, I don't know, gravity exists. So now you can't use that for... I'm picking a somewhat ridiculous example, but they don't want to have to be blocked out of information they already have or that's in the public domain or so forth. All right, so now we're still sort of in review of stuff that you might have followed if you'd seen previous things, but the judge is going to go through all of this in some detail to establish why the judge is making the rulings they do. So Nealon later gets a box of containing a thumb drive and various firearm blueprints at his house, but he doesn't know the contents of the thumb drive and he lacks the software to open it. And he's going to sell these on to KE Arms, but he says that he does not believe that the thumb drive contained any information that be considered protected intellectual property because he'd publicly shared anything that might have been treated as proprietary information on the internet or directly to firearms enthusiasts or firearm businesses. He's like, yep, we don't have any trade secrets here because everything I knew I shared with the public. And he doesn't have any, trademarks or patents or anything like that. So what kind of intellectual property is left? Maybe some new imaginary kind, which seems to be how GWACS likes to roll. All right. So carrying on. Fagan states that KE Arms used the CAM files for the KE-15 to develop the new lower receiver known as the KP-15, and Fagan states that KE Arms also consulted outside experts to convert the KE-15 aluminum receiver into the KP-15 polymer receiver. This is important because GWACS says, listen, they copied our polymer, receivers to make their own version. Whereas Russell Fagan says, no, we actually started with the KE15 and then we made that into a polymer version, which seems like it makes sense. And critically, we're talking about variants of the AR-15, right? All of these are variants of the same kind of rifle, which is at this point public domain. Anybody, like lots of people are making AR-15s because the intellectual protection, like the property protections, the patents have expired. So yeah, it's not hard to imagine that other people can also come up with the idea of a monolithic polymer lower receiver. So GWACS asserts that KE Arms used the CAD15 design files to create the new receiver, and GWACS further asserts that KE Arms witnesses have falsely claimed to develop the new receiver from scratch. So they're going, you liars, which is a pretty big allegation. You're going to want to be able to back that kind of thing up where you've got contradictory evidence under oath. You want to bring your receipts on that. You want to have receipts. So, in particular, GWACS sent an investment packet to KE Arms disclosing that GWACS was seeking financing to begin production of a new version of the Mark III and Mark IV, and GWACS claimed it had improved its manufacturing techniques to reduce production costs. Okay. GWACS also claims that its new models would have features that were not otherwise available on the marketplace, such as an adjustable buttstock and an integrated single-point sling mount. This seems like a bold claim because adjustable buttstocks and single-point sling mounts are really common features. Like, really, really common features. This is like saying, hey, I'm going to invent a new kind of car, and it's got these features no one else has seen before, like seat belts and brakes and a rear bumper. Yeah, I mean, these are just really super common. Why would you want an adjustable buttstock? Well, it allows multiple different people to use the same rifle comfortably. Instead of having to sort of shop around for a rifle that fits you just perfectly, you can adjust it. That's great. And similarly, if you want, multiple people sharing it, it's really quick and easy to switch between those. Sometimes if you're doing a shooting competition, you might adjust the buttstock on the fly for various reasons. Sling mounts. Slings are fantastic. There's all sorts of ways you might use a sling for everything from carrying the rifle around as well as to steady the rifle. There's various techniques that use a sling to steady the rifle when you're firing it. So sling mounts are real common. They appear on rifles all over the place. All right. On July 10th, 2018, GWACS made a public disclosure that it was unable to manufacture any of its CAD15 products, and it was virtually sold out of Mark II receivers, and it announced that it was finalizing the design of the Mark III that incorporated features recommended by Russell Fagan, aka SinistralRifleman.com. Which kind of suggests that some of this was already in the head of Russell Fagan, which is going to be a problem for them later, right? Because if they're saying, hey, this is a trade secret, this is uniquely known to us, well, looks like it wasn't uniquely known to them. It was also known to Russell Fagan. All right, so carrying on here. After GWACS had publicly disclosed on its website that it was unable to produce more Mark II receivers, Brownells offered to lease or rent GWACS Mark II molds to produce the receivers for the What Would Stoner Do rifle, which is a project that KE Arms was involved in, or Carl Casarda and InRange, to produce a particular sort of style of rifle. But GWACS told Brownells that having the molds get out of their facility is a non-starter. Okay. GWACS proposed to Brownells that it could provide a price for retooling the existing Mark II molds, and Brownells forwarded this proposal to Fagan. However, the evidence provided by the parties does not show that any agreement was reached concerning use of or retooling GWACS Mark II molds. KE Arms designed a new lower polymer receiver and provided pricing information to Brownells in 2019, and KE Arms claimed that the new receiver, known as the KP15, was essentially the same as KE-ARM's existing KE-15, but was made out of polymer instead of aluminum. And you can see from the naming scheme, KP-15, I'm guessing, is, for polymer. Yeah, this seems like a credible account, right? You'd want to have some evidence to counteract this notion that it was just we adapted our existing firearm to make it out of polymer. On April 7th, 2020, Russell Anderson, GWACS Sales and Marketing Director, sent a cease and desist letter to KE-ARMS alleging that KE-ARMS was attempting to develop a GWACS CAV-15 Mark III in direct conflict with our intellectual property rights. Now, normally here, if you are alleging that somebody is doing something in violation of your intellectual property rights, you want to be real sure that you have some intellectual property rights. That's an important first step, right? You're stealing my car. I want to be really sure that I actually own a car. GWACS doesn't take that step. Anderson stated that GWACS purchased all molds, equipment, and intellectual property from Cavalry for the Mark II and the Mark III, and that GWACS owns the exclusive rights to these materials, and Anderson claimed that GWACS shared this information with KE-ARMS pursuant to an NDA in 2015. Now, this is where things, we keep coming back to this problem of GWACS seems to think they have more intellectual property than they do. And quite frankly, it appears that GWACS got bad legal advice. That's what it looks like from all of this. Or no legal advice is another possibility. When you're buying a business or substantial business assets, you should really get a lawyer to review that to make sure you're actually getting all the things you think you're getting and all the things you want to be getting out of this. And ultimately, if your lawyer screws that up, then you have a cause of action against the lawyer. The more I look at this, the more I keep thinking that GWACS sued the wrong people. Maybe they should have sued their lawyer. The problem is that the lawyer that is representing them in this seems to be like they've got the same guy involved. And that's a problem because maybe he shouldn't be. Maybe that's a situation where it's like, hey, I can't represent you on this because you might need to be suing me. And lawyers actually can have an ethical obligation to do that. If as a lawyer you screw up, you may actually have an ethical obligation to recommend to your client that they sue you. A big example of this is if you miss a limitation period. And a limitation period is like a lawsuit can only be filed within a particular time, and outside of that time, that lawsuit is dead. You may not be able to file it at all. So if as a lawyer you screw up and you miss that limitation period, now you've created liability where the value of that lawsuit might be on you. You might end up, and you can have a literal ethical obligation to tell the client, one, I screwed up, hey, sorry, you had this perfectly good claim. I screwed up and didn't file it in time, so you now have no claim. But you should sue me. And then the client probably will. Because, yeah, you can end up owing a lot of money as a lawyer by missing those deadlines. So that's kind of this thing that's hovering over this entire lawsuit is, are they even suing the right people? Okay, carrying on. Anderson demanded that KE-ARMS cease and desist the manufacture and marketing of its product that allegedly bore a likeness to the Mark II and Mark III that was the exclusive intellectual property of GWACS, but Anderson stated that GWACS would be willing to discuss a licensing arrangement with KE-ARMS. So we would be willing for you guys to pay us to keep making this stuff. Now, given that we're talking about sort of AR-15 analogs, it's kind of interesting to see that we're, when we're saying that it bears a likeness. How alike does it have to be? I'm guessing, it would have to be pretty alike because there's a lot of different AR models out there, and most of them look very samey for, fairly obvious reasons. It's a good design. People aren't sort of messing with it too much because it's a good design. Anderson concluded by threatening that GWACS would be forced to take legal action if the parties could not quickly work out a licensing agreement. Pay us or else is what this comes down to. GWACS did not receive a response from KE Arms, and it resent the email to KE Arms and copied Paul Levy of Brownells on the email. Now, why is this relevant? Well, because Brownells is probably going to take some response to this, right? Hey, this product that you're working on getting to market is going to be potentially bound up in litigation. That tends to discourage people from going to market with things, right? Hey, you're going to get sued if you do this. All right, carrying on. On July 15th, 2020, GWACS filed this case alleging breach of contract claims against KE Arms, SST, and Brownells, which are the 5th, 8th, and 9th causes of action. Now note, a bunch of causes of action have already been killed, but these are some that are still going. GWACS also alleges claims for misappropriation of trade secrets and intellectual property against KE Arms, Fagan, and Nealon, 2nd and 6th cause of action, and a claim of breach of the implied covenant of good faith and fair dealing against KE Arms, Fagan, SST, and Brownells, 7th cause of action. KE Arms filed counterclaims against GWACS and other related entities and persons for breach of the implied covenant of good faith and fair dealing, interference with prospective economic advantage, business disparagement, and deceptive trade practices and unfair competition. KE Arms also seeks a declaratory judgment, first claim, that it complied with the NDA when it developed its lower polymer receiver. So that's the whole big long list of claims we're dealing with, All right, now we're going to skip over some procedural background about how this ends up in Oklahoma, and we're going to carry on here. We don't want this to take too long, but we're going to still do a deep dive and really analyze all of this. So each party has filed a motion for summary judgment, and GWACS has filed a motion to dismiss its claims against Nealon with prejudice. So GWACS does not want Nealon to be continuing to be involved. They've said, you're not at fault, but there's going to be some disputes as to how Nealon gets out of this, because he's also asking for summary judgment with respect to the claims against him and opposing the dismissal. So they both want Nealon out. It's just the question is terms. So based on the dismissal of claims and the court rulings, GWACS' remaining claims are its breach of contract claims against KE Arms, SST, and Brownells, 5th, 8th, and 9th cause of action, misappropriation of trade secrets against KE Arms, Fagan, and Nealon, 2nd cause of action, misappropriation of intellectual property against KE Arms, Fagan, and Nealon, 6th cause of action, and breach of the implied covenant of good faith and fair dealing against all defendants, 7th cause of action. GWACS has renewed its motion to dismiss its claims against Nealon, and GWACS seeks leave to dismiss its claims against Nealon with prejudice to refiling. I think previously they'd applied to dismiss without prejudice, and now they've said, we'll dismiss with prejudice. Defendants have filed motions for summary judgment as to all of the claims asserted against them, and defendants have also filed a motion to sanction GWACS for failing to disclose evidence of its voluntary disclosure of alleged proprietary information or trade secrets to third parties. Now, I covered that in a previous video. Basically, GWACS was supposed to have disclosed a bunch of stuff, and they didn't. And so there was an application brought to bring sanctions, including asking for sanctions up to and including dismissal of the claims. So we'll see how the court deals with that. GWACS had denied that they had done anything improper. The court's going to have some thoughts about that too. I thought that GWACS's claims in response were kind of silly, and turns out I'm right, according to the court. So, defendants argue that GWACS intentionally failed to produce discovery materials concerning GWACS' voluntary disclosure of materials to third parties that it now claims are proprietary information or trade secrets. Defendants request that the court sanction GWACS and dismiss GWACS claims for misappropriation of trade secrets and breach of contract. GWACS responds that defendants did not actually request the evidence that they now claim was not produced in pretrial discovery, and the alleged proprietary information or trade secrets contained in the new evidence is not the same proprietary information or trade secrets that is the subject of GWACS's claims. Basically, they were saying you didn't ask in exactly the right words, so nuh-uh. And yeah, it was not a good argument on that. All right. The evidence at issue concerns the communication of GWACS Vice President of Sales, Michael Shell Jones, or Michelle Shell Jones, with third parties who requested information about GWACS products. Basically, lots of people in the public asked questions about these products, and they were answering those questions as if it was no big deal, which is a big no-no when you're talking about something that is a trade secret. Like if Coca-Cola has a trade secret with respect to the recipe for Coca-Cola. And so if I write to Coca-Cola Corporation and say, hey, I would really like the recipe for your product, can you send it to me? They will send back a very polite letter that will say something like, dear sir, thank you for your interest in our products, but also go to hell. And they won't phrase it like that, but that's what it's going to mean. Instead, they were just answering whatever random questions, which is stupid. Yeah. All right, carrying on. KE Arms made a request for production of all of your communications in native format with Shell Jones concerning the CAV-15 during the relevant period. GWACS refused to provide any discovery in response to this request on the ground that the request was overly broad and unduly burdensome. Okay. On July 19th, 2022, KE Arms was contacted by a former customer of GWACS, Kenneth King, who was asking for information about CAV-15 receivers, and King produced a photograph of the internal workings of the lower receiver that had been provided to him by Jones. Defense counsel immediately sent a letter to GWACS counsel seeking an explanation as to why GWACS failed to disclose Jones' communications with King, and defense counsel asked GWACS to identify any other similar communications relating to the CAV-15 receiver. GWACS failed to respond to the letter, and defendants subsequently learned of 8 additional persons who communicated with Jones about technical issues or specifications of the CAV-15 receiver. That's kind of a big deal, right? So, they note that there's a general rule that the bad faith or intentional destruction of evidence relevant to an issue at trial gives rise to an inference that the evidence would have been unfavorable to the party responsible for its destruction. Problem is that we don't actually have destruction here. We just have failure to disclose, right? So they note defendants have not raised a true spoliation claim, and this is a garden variety discovery dispute that the parties should have resolved without resort to a motion for sanctions. So this is a bit of criticism of KE Arms' counsel. Not harsh criticism, but it's criticism. It's saying, hey, you should have solved this. Now, KE Arms' counsel can't be faulted too much on this one because, in fact, GWACS counsel stonewalled them. So that's relevant here. Defendants argue that GWACS failed to produce evidence of third-party communications with Jones, but defendants have not accused GWACS of destroying evidence. The court agrees with defendants that the withheld information was requested in discovery. So that argument of, nuh-uh, you didn't ask for exactly the right thing, the court says, that's some crap. That's not true. So, yeah. And GWACS claims that defendants failed to request the evidence is meritless. Meritless doesn't sound like strong language, but it's strong language. This is the court laying some smack down in very polite fashion. So they're basically saying, hey, that argument you were raising, that argument is basically the chief product of cows that isn't milk or beef or leather. Yeah, I hate YouTube swearing rules. Carrying on here. Defendants expressly requested that GWACS produce all of your communications in native format with Shell Jones concerning the CAV-15 during the relevant time period. Jones's communication with customers concerning design and pricing information about the CAV-15 certainly fell within the scope of this discovery request, and GWACS's boilerplate objection that the request was overly broad was insufficient to preserve any objection to this discovery request. So let's talk a little bit about discovery. In lawsuits, you will have discovery where both sides have to share information with the other, including information that might be harmful to their case. And because you might have to share information that might be harmful to your case, people find all sorts of reasons to not share that, right? And to try to stymie or block those discovery requests. And one of the things you can't typically do is just sort of throw out these pro forma, objections that are just, that don't mean anything. So you can't just say it's overly broad, because you could say that about any claim. You have to actually come back and negotiate as to what, how to narrow this. Why is it too broad? So they note, there's a case here that they're citing for boilerplate objections that discovery requests are vague or overly broad, do not constitute a response to a discovery request, and the party intending to assert such a request must contact opposing counsel in an effort to narrow the discovery requests. And boilerplate objections to discovery requests can constitute waiver of the responding party's right to object. If you don't object properly, you can lose your objection entirely. That's a big deal, right? So in this case, defendants received the information it requested in discovery from third parties, and the evidence shows that GWACS counsel consistently refused to meet with defense counsel after it came to light that GWACS withheld relevant evidence in discovery. That's some criticism. That's some fire. However, notwithstanding that, K-Arms isn't going to get what they want, but they're also kind of going to get what they want. And I'm going to have to explain that because I know that makes very little sense. But they don't get the sanctions they want. They just get some of what they need through an alternative means. So let's carry on here and I'll explain what we're talking about. The court finds that it is a sufficient sanction that the court will consider the evidence provided in defendant's supplemental filings and declarations when ruling on the pending motions. So this stuff in this order here. And defendants may use this evidence if the case proceeds to trial. However, the court declines to impose the sanctions requested by defendants, such as dismissal of claims or an adverse inference against GWACS, and defendant's motion for spoliation sanctions is denied. Now, keep in mind when you're hearing that this motion for spoliation sanctions is denied, but that this evidence is going to be allowed in, we're going to see where this evidence lands and how it actually affects this, because this evidence is going to be critical for knocking out some of GWACS's claims. So K-Arms doesn't get what they want, but they also get what they want. Yeah. So all defendants seek summary judgment on GWACS claims against them. K-Arms argues that GWACS does not actually possess any intellectual property or trade secrets, and GWACS claims of misappropriation of intellectual property or trade secrets are meritless. Now, the court's not going to entirely agree with it, but they're going to largely agree with it. K-Arms also argues that it did not breach the parties' non-disclosure agreement because GWACS did not disclose anything that would qualify as proprietary information, as that term is defined in the NDA. Basically, they're saying GWACS doesn't have any secrets to be breached. So, tough. GWACS argues that it is entitled to summary judgment on K-Arms' counterclaims on the basis that GWACS' cease and desist letter was made pursuant to a litigation privilege, and K-Arms' counterclaims are barred as a matter of Oklahoma law. GWACS also argues that K-Arms has not come forward with evidence that it suffered any harm as a result of Brownell's receipt of the cease and desist letter. All right, so we're going to cover all of this. Summary judgment. Now the court is going to tell us what summary judgment is, which is great because we could use a refresher, right? And the court is going to also sort of have some comments about the value of summary judgment in the litigation process. I think this is all worthwhile stuff. I'd otherwise just kind of give you a really brief summary of summary judgment, but I think this is actually really kind of cool because I'm a nerd. All right, summary judgment pursuant to the federal rules of court is appropriate where there is no genuine dispute as to any material fact and the moving party is entitled to judgment as a matter of law. So if everyone agrees as to what the facts are, then the court can just decide the issue, right? Or similarly, if people aren't in agreement, but there really isn't any actual basis for any disagreement. So sometimes that happens as well, where the evidence can be so overwhelming. So the plain language of Rule 56C mandates the entry of summary judgment after adequate time for discovery and upon motion against a party who fails to make a showing sufficient to establish the existence of an essential element to that party's case and on which that party will bear the burden of proof at trial. This probably deserves some explanation. So usually if you want to make out a claim in law, you have to establish several different facts, several different things, which lawyers call the essential elements. So let's say, for instance, in a criminal trial, if Joe is charged with assault, the Crown or the prosecution here in Canada would have to prove that that Joe applied force or caused somebody to reasonably apprehend that force was going to be applied to them, that this was, in some fashion intentional and not like via reflex action or something like that, and various other things, right? So those are the essential elements. And if you bear the burden of proof at trial, it means those are the things you personally have to prove to make out your case. All right, enough explanation. We're going to move on here. Summary judgment procedure is properly regarded not as a disfavored procedural shortcut, but rather as an integral part of the federal rules as a whole, which are designed to secure the just, speedy, and inexpensive determination of every action. What the court means here is that summary judgment isn't something to be considered, kind of bad form. It's actually a really important way the court deals with things. And so you shouldn't be super reluctant to use summary or to grant summary judgment. You just got to actually apply the proper test. So when the moving party has carried its burden under Rule 56C, the moving party is the party applying for summary judgment. Its opponent must do more than simply show that there is some metaphysical doubt as to the material facts. Where the record taken as a whole could not lead a rational trier of fact to find for the non-moving party, there is no genuine issue for trial. So you can't, if there's 600 witnesses who all say that one thing happened, you can't bring one person who is, blind and mentally ill and, unable in any way to actually testify to the facts that they would, to say the opposite, right? Because that just wouldn't be plausible at a trial. The mere existence of a scintilla of evidence in support of the plaintiff's position will be insufficient. There must be evidence on which the trier of fact could reasonably find for the plaintiff. So a genuine triable issue. In its review, the court construes the record in the light most favorable to the party opposing summary judgment. And that's because you're not having a full trial, right? So if you have to say, we're going to look at this the best way we can for the people who still want the case to proceed. So that is a major set of brakes on summary judgment, is this aspect right here. It's a really important aspect of the summary judgment process. Before reaching the parties' motions for summary judgment, the court will consider GWAC's request for leave to dismiss its claims against Nealon with prejudice. All right. So before they go to summary judgment, they're going to say, hey, does GWACS get to just drop the claims against Nealon? Because if they can, then they're not going to have to consider Nealon's summary judgment aspects. So skipping ahead here a little bit, they note, GWACS has appropriately sought to dismiss its claims against Nealon with prejudice to refiling, and the court does not find that any other conditions are required to afford substantial justice to GWACS and Nealon. Nealon argues that attorney fees are a necessary condition for dismissal of GWAC's claims against him. but he's not come forward with any evidence that he's actually incurred attorney's fees to defend against GWACS's claims. The court's not going to give you money to pay back your lawyer's fees if you didn't have any lawyer fees. So that would have been important evidence to bring forward if you want to get paid for that, right? The court doesn't pay out just because you want money. You got to show that you're owed money. So that's a big problem for Nealon here. Nealon will not be prejudiced if GWACS is permitted to dismiss its claims against him with prejudice, and this will effectively terminate the litigation as to Nealon. Done. Nealon is finished. He's out. He's free. It's a good day for Nealon. Nealon is one of the big winners of this case. Notwithstanding the fact that he doesn't walk away with any money for attorney's fees, he's a big winner here. We're going to put a big old medal on Nealon. Nealon's motion for summary judgment is now moot. And what moot means is basically just that it's irrelevant because it's somehow been overtaken by another decision. So in this case, we can't grant him summary judgment because he's already out of the case. He's already got what he wants, which is to be out of the case. All right. Defendants seek summary judgment on all of GWACS's claims. K. Arms, Fagan, and Brownells argue that GWACS did not actually produce any proprietary information pursuant to an NDA, and plaintiff cannot meet its burden to show that any defendant violated an NDA. K. Arms and Fagan assert that GWACS did not disclose to them any materials that could be considered intellectual property or trade secrets, and they are entitled to summary judgment on GWACS's claims for misappropriation of intellectual property or trade secrets. Finally, defendants argue that the parties had an ordinary commercial relationship, and Oklahoma law does not recognize a claim for breach of implied covenant of good faith and fair dealing, absent a special relationship between the parties. And special relationship is going to be defined. This is not like romantic or anything like that. This is a particular kind of interaction that applies to particular kinds of contracts. So, yeah, we'll get to it, but I'm just going to say, like, special relationship has a very specific meaning. All right, carrying on. Intellectual property and trade secrets. Before considering the parties' arguments as to specific claims, the court will review the various contracts to determine what intellectual property, if any, GWACS possesses, and if any of the materials produced to defendants pursuant to an NDA could qualify as a trade secret under state or federal law. So, that already sounds bad for GWACS, right? What intellectual property, if any, they might produce? You don't ever want the court to be wondering that question in an intellectual property lawsuit. That's a bad place to be. Yeah, okay, carrying on. So they review the stuff that was sold, and they note there was no representation in the asset purchase agreement that Cavalry possessed any patents, trademarks, copyrights, or any other type of legally exclusive intellectual property rights to the assets being sold to Sinistral Shooting Technologies. This is real bad for GWACS because if Sinistral never gets any of these things, then Sinistral can't sell them to GWACS. Okay, carrying on, and they're going to review the asset purchase agreement. We already covered that, so we're not going to do it again. Although the asset purchase agreement states that GWACS purchased intellectual property, the agreement does not state that Sinistral Shooting Technologies was representing that it had any exclusive or protected rights to the drawings, prints, molds, or other property sold to GWACS. This is a lawyer screw-up. This to me looks like a screw-up on the part of the lawyer who was doing that purchase agreement. Yep. If you think you're buying IP, you'll want to make sure that that IP exists and is owned by the people you're buying it from, and you at least want to get a representation where they promise that that IP exists. But they didn't, because somebody messed up. Whoops. Whoops. Yeah. All right, carrying on. In 2016, Nealon claims that he found several boxes containing a thumb drive and blueprints of firearms at his home. He states that he did not know the precise contents of the thumb drive because he didn't have the software to open it. Nealon claims that it is unlikely that the thumb drive contained any confidential or proprietary materials because he'd freely shared materials relating to the CAV-15 receiver at trade shows, forums, and on the internet, which is really bad for trade secrets, right? That's how you murder a trade secret. Nealon believed that he'd made such extensive public disclosures concerning the CAV-15 receiver that the materials he found in 2016 could not be considered protectable intellectual property because he already shared everything, right? Cavalry Medical sold KE Arms 2 boxes of blueprints and the thumb drive. GWACS believes that Nealon had retained a copy of the CAV-15 files that it purchased from Sinistral Shooting Technologies, and GWACS suggests that these files were included in the material that Nealon sold to KE Arms. Okay, let's see how they back that up. However, GWACS cites no evidence to support its belief that Nealon retained a copy of the CAV-15 files that were sold to GWACS, and GWACS's speculation on this matter cannot be used to support a genuine dispute as to a material fact. So basically, GWACS said, well, it's possible that could have included a copy of the CAV-15 files. We don't see how they could possibly have designed a polymer receiver without this. So we think that, you can't just make stuff up. That's really what they're getting in trouble here for, is for just making some stuff up and assuming that it must be true. But that's not how the courts work. Sorry, you gotta have actual evidence. Evidence is the thing that courts run on, not just like theories in your skull. Yeah. We can laugh at this because it's not us. I'm so glad not to be these people. All right. GWACS repeatedly claims that defendants misappropriated its intellectual property, but GWACS must establish it disclosed information to defendants that was actually intellectual property, as that term is commonly understood. This is looking real bad, right? Like, you want to say that your intellectual property was disclosed? What intellectual property? What? Yeah. GWACS purchased certain assets from Sinistral Shooting Technologies, and these assets included design files or drawings related to CAV-15. However, GWACS could purchase rights to the assets only as good as the rights possessed by Sinistral Shooting Technologies, and Sinistral Shooting Technologies did not have any patents or other type of exclusive intellectual property rights to the property being sold. You cannot wish a patent into existence just by trying to buy one from some random person who doesn't have one. That's not how it works. This is not when you wish upon a star, you're going to just create this. There's legal processes. And you can do a patent search. You can check if a patent exists. That is a thing that can be done and would be normally considered due diligence if you think you're buying a patent. Hey, does this exist is a basic thing you might check if you are thinking you're buying a patent. Another basic step that you might take is to actually specify that you're buying a patent if you're buying a patent. And you identify it specifically with here is the specific registry entry for this patent. We are getting this specific, patent. So Nealon admits that he freely shared information about the manufacture and design of the CAV-15 with customers and on the internet, and the agreement between Cavalry and SST does not suggest that either of those parties believed that SST was purchasing any property that was protected by a patent or that was considered intellectual property under state or federal law. You remember my example of the book. They're buying a copy of the book. They're buying the molds and not the underlying intellectual property. In the case of the book, it's because I don't own it. But in the case of this, it's also because it just doesn't exist. it's something GWACS imagined or wished very hard that they had. So GWACS complains that Fagan and SST may have committed fraud, which is a big claim. You gotta, anytime you say fraud, you want to be able to back that up. By falsely representing that SST had exclusive rights to certain property before GWACS and SST entered in an asset purchase agreement in November 2011. This has nothing to do with the existence of intellectual property rights now or at the time the asset purchase agreement was executed, and there is no evidence suggesting that Fagan represented that SST was selling GWACS a patent or other protected intellectual property rights. You know, I have exclusive ownership of this pen. That doesn't mean I own any patents relating to the pen. It just means that I am the sole owner of this pen and can sell it if I want to. You know, as opposed to, I don't know, if you own, 20 shares in Microsoft, you can sell those 20 shares, but you can't sell Microsoft to someone because you're not the exclusive owner. All right. I don't know if that's the best example, but we're going to run with it. That's our example for right now. So the court will not refer to the CAV15 receiver in any of its forms or materials related to the CAV15 receiver as intellectual property. Damn. That's a bit of a smackdown here. Information about GWAC's financial condition is also not intellectual property, although this information may be protected as a trade secret or as proprietary information disclosed pursuant to an NDA. That's also a bit of foreshadowing, right? That's telling you where some of the claims might be going. Due to GWACS's failure to identify any intellectual property in its possession, K-Arms and Fagan are entitled to summary judgment on plaintiff's claims for misappropriation of intellectual property, which is the sixth cause of action. GWACS also asserts a claim against K-Arms and Fagan for misappropriation of trade secrets, and the court will consider what, if any, information relating to the CAV15 or GWACS financial status qualifies as a trade secret under state or federal law. And there's a big definition of trade secrets, which we're gonna skip over, but it, all types, forms and types of financial, business, scientific, technical, economic, or engineering information. Which basically, however it's stored or memorized or whatever, if the owner has taken reasonable measures to keep such information secret and the information derives independent economic value, actual or potential, from not being generally known to and not being readily ascertainable through proper means by another person who can obtain economic value from the disclosure or use of this information. So that's one definition. I'm not going to read all the definitions because super boring. All right. The court initially notes that the CAV15 receiver in any of its forms is not patented and is a publicly available product, and there's no evidence that GWACS was in the process of obtaining a patent for any aspect of the production or design of existing models of the CAV15 receiver. And I'm going to suggest that there's probably a really good reason for that, which is probably that they can't. None of this seems like something that was patentable because it was all stuff that was, the AR-15 was known to other people beforehand. All right. The Supreme Court has explained that trade secret laws are primarily intended to prevent industrial espionage, and the public at large remains free to discover and exploit the trade secret through reverse engineering of products in the public domain or by independent creation. So remember my example of Coca-Cola and how the recipe for that is a trade secret. Well, if I am some master food scientist, which is a thing, and I independently reverse engineer the formula for Coke. Like I figure out how to manufacture Coca-Cola in my basement, in a bathtub. Well, then I'm fine. Like that's legitimate. I can't be sued over that. But if instead I hire a team of ninjas to break into the Coca-Cola facility and they steal the secret recipe under cover of darkness with smoke bombs and shuriken and, it's a whole production. Then I could probably be sued for violation of the trade secret because, that's some espionage. Or similarly, if I just pay an employee at Coca-Cola and I'm like, hey, steal the secret for me, again, that would probably not be okay. Big difference, right? Coca-Cola, if they don't have a patent on it, can't prevent me from doing independent research and evaluation. And in fact, I can do that even with, like, I can use the can of Coke that I bought in order to give me clues. Like, how much sugar is in this? Well, I can run it through a mass spectrometer and find that out. And that can help inform my recipe decisions. Yeah. All right, so under the DTSA, the acquisition of a trade secret by improper means does not include reverse engineering or independent derivation, which is expressly permitted by the statute. So if I figure it out on my own, that's okay. The ninjas method is not allowed. No ninjas allowed. I need a big anti-ninjas sign. I'm probably not going to make one, but I should. All right, defendants have produced evidence showing that GWACS provided its customers photographs of the interior of the CAV-15 receiver, extensive information as to ways to modify the receiver, product specification and measurements, and the composition of the polymer. Remember the spoliation sanctions and how they said, hey, we're not granting the sanctions, but you can use that evidence? Here's that evidence. It's happening, folks. It's happening right here. So this is where that additional material is gonna save a whole lot of trouble. The evidence shows that GWACS generally failed to maintain secrecy over the design, composition, and features of the Mark I and Mark II that were available for purchase by the general public. Jones freely disclosed photographs, design specifications, and information about the composition of these products with anyone who requested this information, and it appears that GWACS had no policy of maintaining secrecy over this information, which is, again, important if you want it to be a trade secret, that you maintain secrecy. If Coke posts the secret recipe to Coca-Cola on their webpage, then it's not a trade secret anymore. So this information was also not subject to a patent or any other type of intellectual property protection, and defendants were free to reverse engineer products that were available for purchase in the public marketplace. However, the court finds that there is a genuine dispute as to whether information about the design, manufacture, or features of the Mark III and Mark IV were trade secrets. There is no evidence suggesting that defendants were aware of GWACS disclosures of the feature of the Mark III or Mark IV, and defendants learned of the features of these products pursuant to an investment packet that was disclosed to defendants subject to an NDA. Now, I'm not so sure about this one because we already saw that GWACS put out a thing saying that features of the Mark III were suggested by Russell Fagan, who is kind of mentioned and kind of relevant here. So that kind of suggests that he would have been aware of those new features, right? So a reasonable jury could, now note the could, it's not will, not would, not probably, it's could potentially find that information related to the manufacturer and design of the Mark III and Mark IV qualifies as a trade secret under state or federal law. As to GWACS's financial information, the court finds that there is a genuine dispute as to a material fact concerning GWACS's efforts to maintain the secrecy of its financial condition and pricing of its new products. GWACS made general public announcements that it was essentially out of stock of its existing lower polymer receivers, but this is not the same as a public declaration concerning GWACS's financial condition. I mean, what they're saying is maybe they're sitting on like this giant war chest of money and they can spend it on whatever. Like, so they're saying that might be a proper trade secret here. Defendants have not produced evidence suggesting that GWACS publicly disclosed that it was seeking investors, the amount of the investment that GWACS was seeking, or that the pricing for the proposed Mark III and Mark IV were generally known to the public. GWACS took the step of requiring KE Arms and SST to execute an NDA before reviewing this information, and the information was not available to the public, and this tends to show that GWACS intended to maintain secrecy over its financial information. So GWACS has lost on certain aspects of, things existing as intellectual property. However, the sort of bottom line on this one, GWACS has adequately shown that its financial information may, not does, may constitute a trade secret. So some of the claims on GWACS's end will be allowed to continue. Okay, misappropriation of trade secrets, the second cause of action. So GWACS asserts claims for misappropriation of trade secrets under federal and state law, and under either statute, a plaintiff must come forward with evidence establishing 1, the existence of a trade secret, 2, the acquisition, use, or disclosure of the trade secret without consent, and 3, that the individual acquiring, using, or disclosing the trade secret knew or should have known the trade secret was acquired by improper means. Now you already can get a feel for where this is likely to be going, right? Because the existence of a trade secret has been a big deal. This is unlikely to prevail with respect to anything about these particular receivers because GWACS was sharing it with anybody who asked. Really, almost anybody who'd listen. Hi, we're calling about your car's extended warranty, and also did you know that this is how we make our monolithic polymer receivers? Yeah, so with respect to that, you can tell that this claim is not likely to go forward. But there is some details, like they noted about the Mark IV receivers and about the financial details. So we already get a feel for where this is going, right? All right. So KA received information about GWACS's financial condition pursuant to an NDA, and KA was aware that financial information identified as proprietary by GWACS fell within the scope of an NDA. The evidence shows that KA developed a competing product after it learned that GWACS was currently unable to produce more of its existing products or fully develop the Mark III and Mark IV for production and distribution. Viewing the evidence in a light most favorable to GWACS, which is how you do these, right? This isn't a sort of even weighing. You definitely need to sort of consider that where there's going to be contradictory evidence, you'd say, what happens if the jury finds on this contradictory point for GWACS? A reasonable jury could find that KA chose to develop a competing product after learning that GWACS lower polymer receivers would essentially be leaving the marketplace. This could reasonably support a finding that KA misappropriated information it received pursuant to the NDA and that it acted with the necessary intent. So they're saying this could be the basis of a finding in front of the jury. To be clear, GWACS may not proceed with a misappropriation of trade secrets claims as to alleged misappropriation of the design, production, or features of the Mark I or Mark II receivers, and this claim is limited to financial information that was disclosed pursuant to an NDA and information related to the design, manufacture, and composition of the Mark III and Mark IV receivers. So really narrowing the scope of what's allowed to be argued here. But the claim stays in, right? It's not thrown out. Breach of contract. Defendants argue that they did not use any proprietary information in violation of the NDA because the NDA does not prohibit them from using information disclosed pursuant to the NDA if the information was already in their possession or was publicly available. You know, just because you told us this, if we already knew it, we're not going to be banned from using things we already knew or that we would have been able to find just searching the internet. Defendants also argue that GWAC's interpretation of the term proprietary information is so overly broad, vague, and generic that it would be impossible for KA Arms to even compete in the marketplace, and the NDA does not prevent KA from independently developing and marketing its own products. GWACS hasn't really been clear on what, their intellectual property is, but they've basically described proprietary information as everything. All right, let's skip over a bunch of aspects here because we're just trying to cover the good stuff, right? So the court will initially consider what information disclosed by GWACS pursuant to the NDA can be considered proprietary for the purpose of a breach of contract claim. In response to a discovery request, GWACS stated that the proprietary information disclosed to defendants included, it's going to be a big long list, folks, financial information of Armory, GWACS, that Armory was seeking investors for continued manufacturing and development, total CAV-15 Mark II lower sales volume, CAV-15 Mark II sales following in-range videos, its intent to use Mark III and Mark IV for future CAV-15 models. That one seems stupid to me. Hey, the first one is Mark I, the second one is Mark II. What do we think the third and fourth versions are going to be called? Like Bob and Sally? No. That one's a reach. That one's a real reach. Financial projections for future CAV-15 production and sales, drawings and renderings of the CAV-15, the Mark III CAD renderings and functionality improvements to include several features that were included in the KA polymer receiver, and the Mark IV adjustable stock CAD renderings and functionality. Okay, so some of those are less crazy and some of them are more crazy. Let's keep going. GWACS's financial information may reasonably qualify as proprietary information because defendants have not shown that GWACS's financial condition or its proposals for investment were public knowledge. Information about the design or functionality of existing versions of the CAV-15 receiver, such as the Mark I or Mark II, does not constitute proprietary information because the product was available to the public without any type of intellectual property protection. They sold these to the public. Anybody could have cut one open and seen how it looks. GWACS was sending this information out to anybody who would ask. And yeah, there's no patents, there's no trademarks, there's no anything. This is just open for whoever. Any person could replicate or reverse engineer these products, and design information about the Mark I and Mark II falls under public domain exception to the definition of proprietary information in the NDA. As to information related to the proposed Mark III and Mark IV receivers, these products were not publicly available, and the court has determined that there is a genuine dispute as to whether KEA relied on GWACS's disclosure under the NDA to develop a new polymer receiver. The court finds that the same information that qualifies as a trade secret should also be treated as proprietary information for plaintiff's breach of contract claim. Which isn't surprising, right? The court's already made this one ruling. They're going to apply that ruling to various circumstances. Defendants argue that GWACS conceded in pretrial discovery that no proprietary information or trade secrets were disclosed to defendants, or that GWACS was actually harmed by defendants' conduct. Defendants requested a deposition of GWACS corporate representative pursuant to the Federal Rules of Court, Section 30 sub B sub 6, and the notice of deposition directed GWACS to produce a person knowledgeable with the proprietary information and trade secrets that were allegedly disclosed to defendants. Defendants claim that GWACS corporate representative, Gudgel, so that's Judd Gudgel, what a name, was unable to provide anything other than vague and unsubstantiated testimony in response to questions concerning the specific proprietary or trade secrets that were allegedly exploited by defendants. Here's where we're going to get into something that might be seen as really the only error that KA's counsel made, and I don't know that it's an error because this could have really gone either way. This might just be a tactical decision that didn't work out. So I don't know that I can call this, a blunder or, an error or a mistake or anything like that. It just doesn't work out in the end. But, I mean, I think it's fair to say that once, in hindsight, it's an error. I just don't know if it's something that I might have made the same call, is kind of what, I guess, where I'm going with this. Defendants take the position that Gudgel's deposition testimony is binding upon GWACS, and Gudgel's failure to provide adequate responses to defendants' inquiries require the court to enter judgment in their favor as a matter of law. Now, if you remember, we went over some of this deposition transcript, and he's like, well, everything, right? It covers everything. So, KA's counsel was basically saying, listen, he doesn't even know what their proprietary information is, so come on. But the court's not going to agree with that. There is no dispute that defendants served notice to take the deposition of GWACS corporate representative, and the notice of deposition stated that GWACS corporate representative should be prepared to provide information concerning the proprietary information you claim KA used, disclosed, and/or exploited. Gudgel's responses to defense counsel's questions on this issue lacked specificity, and defendants could reasonably have sought clarification on the information that defendants allegedly exploited and the basis for GWACS's damages. However, the court finds that defendants' argument concerning Gudgell's deposition testimony does not provide a basis for the court to enter judgment against GWACS. As with other issues in this case, this is a straightforward discovery dispute that should have been resolved by the parties or by means of a motion to compel, and the remedy for Gudgell's unsatisfactory deposition testimony would have been a supplemental deposition. So he gave you crappy answers, but the proper way to do this isn't to say, okay, well, those crappy answers are your answer and you're stuck. The court is saying that really they should have come back and said, no, seriously, you got to give us a straight answer on this one, and either a motion to compel to say, like, you have to answer this with a real answer, or coming back to ask again. And had they done that, and had they continued to get these vague things, that might have solved this problem. But they didn't. So the court's like, I'm not going to let you just sort of kind of go without this additional step. This, to me, seems like giving GWACS maybe a bit more line than I would have. I think it's a bit more line than they deserve after we've seen the rest of this case. But regardless, that's where the court lands, so that's what we're stuck with. All right. Carrying on here a little bit. So GWACS also alleged a breach of contract against KA, Fagan's, Sinistral Shooting Technologies, and Brownells. And so a key issue is whether each of these defendants actually received proprietary information pursuant to an NDA with GWACS. And they note that this will be different somewhat as to each defendant. So GWACS must identify specific information that was disclosed to each defendant and establish that the information was proprietary under the NDA. They can't just say, hey, you guys exist and we gave you some information. They have to point to very specific details if they want their claim to survive, which of course they do at this stage. Brownells argues that it did not receive any proprietary information from GWACS after it executed an NDA because the information that GWACS provided to Brownells was not confidential or proprietary and was not protected by the NDA. The parties do not dispute that GWACS notified Brownells that it was seeking investors to finance the purchase of new molds and equipment, and that GWACS sought a letter of intent from Brownells as to the number of Mark III receivers it would purchase from GWACS. GWACS argues that it did not publicly disclose that it was unable to produce receivers for the What Would Stoner Do project. However, GWACS posted on its website that it had virtually sold out of Mark II receivers, and it was unable to produce more due to the condition of its molds. Now, I just kind of want to backtrack here. I mean, they're saying that KE Arms used the information that GWACS was unable to produce more as part of how, or that they might be interpreted as having used that to enter the market. But KE Arms is involved in the What Would Stoner Do project, right? So they're trying to do this. And so when it becomes clear that they can't get the receivers that they want for it, they're obviously going to look for a new source, right? And that source might be them making them themselves, or it might be going somewhere else, but they're going to want to look somewhere else. I don't know if that's an NDA violation of just, hey, if you guys can't sell us the stuff, we're going to find another solution. But that'll be a question for the jury at this point. Okay. GWACS has not met its burden to come forward with evidence showing that Brownells breached the NDA by misusing proprietary information, and Brownells' motion for summary judgment is granted. So that is going to, Brownells gets to knock that claim out with respect to them. Fantastic. Fagan is the owner of Sinistral Shooting Technologies, and he sold to GWACS information related to the design and production of the CAV-15 receiver in 2011. SST and GWACS entered an NDA in 2013, and the NDA included the same definition of proprietary information that has been discussed elsewhere in this opinion and order, which we're not going to repeat because we've gone through it. So Fagan had discussions with Brownells and Casarda about the development of a receiver similar to the Mark II for use in the What Would Stoner Do rifle, and Fagan mentioned possible modifications to the existing Mark II design. None of this evidence tends to show that Fagan violated an NDA or that he personally profited from the alleged violations of the NDA, and GWACS wholly fails to tie this evidence to Sinistral Shooting Technologies. Whoops. That's a little bit of strong language from the court there. So we're going to see some even stronger language here. So the evidence is undisputed that SST purchased information about the CAV-15 receiver from Cavalry, and that SST later sold this information to GWACS, and the evidence also establishes that Fagan was personally knowledgeable about the design of the CAV-15 receivers and firearms in general. He's a smart guy. He's a gun enthusiast. He's a gun manufacturer, like a maker. He's the guy everybody in this has been wanting to go to for expertise. So he's got some ideas in his head. This is important here. So the NDA prevented Fagan from misusing proprietary information produced pursuant to the NDA, but the NDA did not prohibit Fagan from relying on his own knowledge of firearms, because everybody has been relying on Fagan's knowledge of firearms, and including GWACS, right? GWACS, we've seen, they've been saying, oh yeah, we've been taking it, we've been taking these suggestions from Russell Fagan. So clearly he has some gun knowledge already in his head. All right. GWACS, this is just ridiculous that they wanted to own the contents of Russell Fagan's head. I mean, I can see why you might want to. He's a smart guy from all accounts here. But, yeah. GWACS's claims against Fagan seem more in the nature of an alleged violation of a non-compete agreement based on his former employment with GWACS, which it sounds like they didn't actually have a non-compete agreement. That would have been a thing to have if you want to act in this way. Yeah. But GWACS has not shown that Fagan or Sinistral Shooting Technologies violated an NDA with the plaintiff. For the same reasons, GWACS has not established that Fagan misappropriated a trade secret. The court finds that Fagan and Sinistral Shooting Technologies are entitled to summary judgment as to GWACS's breach of contract claim, and Fagan is granted summary judgment as to GWACS's misappropriation of trade secrets claim. So, Fagan is having a good day, Brownells is having a good day, Nealon is having a good day. These are all big winners on this case, right? Now we get to less winning. The court reaches a different conclusion as to KEA, as there is a genuine dispute as to whether KEA misused information produced pursuant to an NDA. KEA entered an NDA with GWACS and received an investment packet from GWACS, and the investment packet disclosed GWACS' financial condition and features of the proposed Mark III and Mark IV receivers. KEA developed a competing product, and the new product bore a substantial similarity to KEA's products. I'm pretty sure that the court meant to say to GWACS's products there. Just a proofreading issue. I think that's the only way to read that sentence. So KEA was also aware that GWACS was unable to produce any more of the Mark I or Mark II receivers, and KEA also knew that GWACS would not be able to produce its proposed Mark III and Mark IV receivers. This evidence would permit a reasonable jury to find that KEA violated the NDA, and KEA's motion for summary judgment is denied as to plaintiff's breach of contract claim. Now, really important to understand what this language means. It means that if a jury found with these details, like assuming that these were the facts that came out at court, and a jury found in favor of GWACS, that the court wouldn't be obliged to throw out that verdict, right, as garbage. So, but that doesn't mean that a reasonable jury will, or that the court imagines that that is the most likely outcome or anything like that. This is important just in terms of what is actually happening here. The only thing we've got in this test is that it would permit a reasonable jury to do so, but that doesn't mean that they will. So lots of people might be inclined to misinterpret this. Let's be careful on that. Breach of covenant of good faith and fair dealing. Defendants argue that there is no special relationship between the parties that would support a claim for breach of the covenant of good faith and fair dealing as a matter of Oklahoma law. Now, this is kind of interesting because Oklahoma law is specific on some of these points. So GWACS responds that KEA and Brownells acted in bad faith by developing a competing product using proprietary information obtained by using false pretenses. Wow, they're salty. And defendants' actions breach the implied covenant of good faith and fair dealing. Okay, now, Oklahoma recognizes a common law duty for parties entering a contract that neither party will act to injure the party's reasonable expectations nor impair the rights or interests of the other to receive the benefits flowing from their contractual relationship, which is basically, we expect you're not going to try to cheat the other person in the contract. So that's kind of to be expected, right? But it notes, in ordinary commercial contracts, a breach of that duty merely results in damages for breach of contract, not independent tort liability. And this is important because GWACS wants independent tort liability here. All right, so absent a special relationship between the parties, Oklahoma law does not recognize a tort claim arising out of a breach of contract, because imposing tort liability for every breach of contract would only serve to chill commercial transactions. So that's kind of key. The special relationship that gives rise to tort liability for bad faith is marked by 1, a disparity in bargaining power where the weaker party has no choice of terms, also called an adhesion contract, and 2, the elimination of risk. So what's an example of an adhesion contract? Well, let's say you decide to follow in my footsteps. You want to create another channel. And so you're going to make and you hit monetization. Well, when you do that, YouTube sends you a contract that says, hey, here's our terms for if you want to make money on our channel. Please, please review this. But you don't get to tell YouTube, hey, I actually want a bigger cut. And, in exchange for that, I'll do this, that, and no, it's just you get the terms. Most software contracts, if you see those, it's just a take it or leave it. You can't negotiate anything and so forth. So that's what an adhesion contract is. It's just basically that, and we deal with those things all the time. And the elimination of risk, I'm not actually sure what that refers to in this context, but we don't need to know that here. Because the first part's going to be enough to decide it. So Oklahoma courts have created a narrow exception to this rule in cases in which there was gross recklessness or wanton negligence on behalf of a party. GWACS has not shown that its claim for breach of the covenant of good faith and fair dealing is cognizable under Oklahoma law. Cognizable just means, like, can it possibly fit within Oklahoma law? Is this a thing that can exist in the law? This is an ordinary commercial contract between parties of relatively equal bargaining power, and GWACS has made no argument that there was a special relationship between the parties. Whoops. I mean, and this seems to be just demonstrably correct, right? GWACS and Brownells and GWACS and KEA and so forth have similar bargaining power. They're actually sitting down and negotiating terms here. It's not something like, when you buy something from Microsoft where it's, where you just get the terms that you get. All right. So they note that GWACS produces no evidence that they have a special relationship with any of the parties whatsoever. And they note that this is the lack of a special relationship between GWACS and any of the defendants is a sufficient basis to dispose of GWACS' claim for breach of the implied covenant and fair dealing. So, construing GWACS's arguments broadly, GWACS could be arguing that defendants acted with gross recklessness or wanton negligence, and this could be an attempt to fit GWACS's claim within the narrow exception identified in Bashara. That's a case, right? However, the court finds that the parties are engaged in an ordinary commercial disagreement, and GWACS has not shown that any of the defendants recklessly or intentionally violated the terms of the NDA by developing a competing product. Summary judgment is granted in favor of defendants, so all of them, as to GWACS's claim for breach of the implied covenant of good faith and fair dealing, the 7th cause of action. So everybody gets out of GWACS's lawsuit on that claim. So everyone wins except GWACS. GWACS loses. GWACS argues that its cease and desist letter was sent to KEA and Brownells pursuant to a litigation privilege, and it seeks summary judgment on KEA's counterclaims of breach of the implied covenant of good faith and fair dealing. You already know where that one's going, right? You already know where that counterclaim on breach of, implied covenant of good faith and fair dealing is going. So why would KEA argue it? Well, because you're going to argue this one either way. Because if GWACS had won on the implied covenant of good faith and fair dealing, then they'd still be hitting this claim would still be hitting them in the face. But because KEA and Brownells and everyone else wins on that issue on the other way, GWACS is going to win on this issue here. It's just how that's going to go. Interference with prospective economic advantage, business disparagement, and deceptive trade practices based on this privilege. All right. So litigation privilege. What is litigation privilege? Well, we want to let people engage the courts without worrying about like defamation and so forth. So that means that a lot of statements that might be defamatory elsewhere would be privileged so long as they are part of a court case. Because you can argue things like, hey, I'm arguing that, that Joe is a fraud and cheated me. That might be a defamatory statement if you argued it, if you published that in the newspaper. But if you're arguing that in a court case, well, the court might say you didn't prove your case, but so long as your case wasn't completely frivolous and ridiculous and so forth, you're probably going to be covered by litigation privilege with respect to those things in there. This is also part of why you see sometimes statements of claim in like celebrity cases that can get a little spicy because it's a way that they can get spicy at each other that they can't do in their media statements. Happens all the time. So, all right. So, Oklahoma recognizes a litigation privilege under which attorneys, parties, jurors, and witnesses are immune from defamation liability for statements made in the course of judicial or quasi-judicial proceedings, so long as the statements are relevant to the proceedings. You can't just throw random insults in there and be like, we're protected, yeah. All right. So the privilege has been extended to statements made in anticipation of litigation. This is important because the statement that matters here is a cease and desist letter that GWACS sent out, which is not part of litigation, but it's clearly in anticipation of possible litigation. Now, they note that the litigation privilege does not give free rein to attorneys to defame, and the privilege is applicable if the communication is 1, relevant or has some relation to a proposed proceeding, and 2, circumstances surrounding the communication have some relation to the proposed proceeding. The privilege applies whether the challenged communication is true or false, and now we're going to get to the really good part of this one. As long as the author or speaker of the statement had a good faith belief in the truth of the statement. Now, good faith isn't just, I didn't know it was false. It goes a little bit beyond that. You have to have made some inquiries and done some checking, and that's going to be a problem. It's going to be a real problem. It's going to be a funny problem, at least from my perspective, because it's not happening to me. It's happening to GWACS. But yeah, let's see what we're talking about here. The court finds that there is a genuine dispute as to whether GWACS' cease or desist letter was sent to KEA and Brownells in good faith and not merely to unlawfully interfere with the distribution of a competing product. You might be saying, well, how is that? Because GWACS thought that they had all this intellectual property and so forth. Well, the court's going to get a little bit spicy here. This is where we can see that the court has some opinions about GWACS. GWACS has presented no evidence that it undertook any kind of investigation to understand its own intellectual property rights before sending the letter. And even at this stage of the case, GWACS has loosely used the term intellectual property to describe information that was already available to the public or that could lawfully be reverse engineered. The cease and desist letter is based on a fundamental misunderstanding that GWACS's purchase of equipment and designs from Sinistral Shooting Technologies in 2011 gave it exclusive rights to the CAV-15 and related designs. I find myself remembering there were a bunch of people a while back who bought a copy of a very expensive Dune book and they thought that that gave them the rights to Dune, which it doesn't. You know, that's just a fundamental mistake of law. It's the same thing with, you know, with buying any copy of a book, right? We come back to this example of, you know, my Neil Gaiman book. This is a basic oops. And they should have had a lawyer who could have explained this to them, because that's a real basic oops. So instead, GWACS writes the property that had purchased from Sinistral Shooting Technologies were only as good as the rights held by Sinistral Shooting Technologies, which were none. I mean, Sinistral owned the molds, but didn't own any IP relating to them, which did not include a patent or any other type of protected intellectual property rights. GWACS knew, or should have known, the limitations of its intellectual property rights to the CAV-15 designs, and GWACS continued over-representation of its intellectual property rights gives rise to a dispute of material fact as to whether its cease and desist letter was sent in good faith. This is basically hinting at a concept that in popular culture has been described as copy fraud, right? It's described as copy fraud when we're talking about copyright issues, but really, you know, they're saying you can't claim stuff you don't own and then use that to bully other people around. That's a big deal. This is the court really not being happy with some of what's going on here. Yeah, and this also gets us back to, like, maybe GWACS should have pursued some litigation against its own lawyers and not against some of these other people. Like, maybe they sued the wrong people. Because if they didn't know what intellectual property they had with respect to this, the screw up is their lawyers. That seems to be where this lands. And I have some real concerns. I have some real questions about how this all works out. I certainly would not have been willing to be counsel on both of these files. Because sometimes, you know, you just can't. All right, let's carry on here, because I don't want to get myself in trouble being a little overly spicy, but I have some thoughts. So, while the litigation privilege may broadly protect parties making statements in anticipation of litigation, KA Arms has produced sufficient evidence calling into question whether the statements contained in the cease and desist letter were made in good faith, and the court cannot conclusively resolve the issue of litigation privilege at this stage of the case. GWAC's motion for summary judgment is denied to the extent that GWACS argues that KA's counterclaims are barred by a litigation privilege. All right. I really enjoyed reading that. It was, that's a lot of fun. Intentional interference with prospective economic advantage, business disparagement, and deceptive trade practices. GWACS argues that KA cannot show that it was damaged by Brownell's receipt of the cease and desist letter because there is no evidence that this harmed KA's relationship with Brownell's. The Oklahoma Supreme Court has stated that the elements of a claim of interference with prospective economic advantage are: 1. Interference with a business or contractual right. 2. Malice or wrongful interference that is neither justified, privileged, or excusable. And damage proximately sustained as a result of the interference. So you have to have damage. You can't just use this as a sort of standalone grounds of claim. Even if you weren't harmed, you have to actually show that there was damage there. All right. So carrying on here, the elements of a claim for business disparagement are that 1, the defendant published false and disparaging information about it, 2, with malice, 3, without privilege, and 4, that resulted in special damages to plaintiff. All right, so KA claims that it was damaged by GWAC's conduct because Brownell's didn't market the product as it might otherwise, or might have otherwise, if GWACS had not sent the cease and desist letter. The evidence shows that KA's assertion that it was harmed as a result of GWAC's conduct is speculative at best. That's not good for KA here, right? Paul Levy, the director of product management of Brownell's, testified in his deposition that Brownell's didn't market the product as much as we probably would have otherwise, but he also stated that the What Would Stoner Do rifle had not actually been received for distribution by Brownell's. So it's going to be hard to have reduced sales of a thing that they don't have to sell. right? Levy has no personal knowledge if the cease and desist letter had any effect on KA's ability to timely manufacture and deliver the receivers for the What Would Stoner Do rifle. KA has the burden to come forward with evidence showing that plaintiff's actions proximately caused an injury to KA and that KA suffered damages as a result of plaintiff's conduct. KA has produced evidence suggesting that Brownells may have curtailed marketing efforts for the What Would Stoner Do rifle, but Brownells did not even contemplate terminating its relationship with KA or take any action to cancel the What Would Stoner Do project. Now, I understand that they have now terminated their relationship for completely different reasons, and so that would have been a problem if this ended up going to trial on these issues in any event. So Mike Kenny, the owner of KA, admitted that KA was in agreement with Brownells to cease marketing the What Would Stoner Do rifle, and the cease and desist letter sent by GWACS did not result in any long-term damage to KA's relationship with Brownells. So yeah, that is what it is. So summary judgment should be granted in favor of GWACS on KA's counterclaims of intentional interference with prospective economic advantage, business disparagement, and deceptive trade practices. So we've lost a whole bunch of additional claims. These claims are falling like, like trees in a hurricane. Like this is, we're just seeing a real slaughter going on here as to all of these claims. All right, let's keep going. We're almost to the end. In fact, we're at the, it is therefore ordered. This is my favorite part because we're just about done. So it is therefore ordered that defendant Brownells Incorporated motion for summary judgment and defendants Russell Fagan and Sinistral Shooting Technologies motion for summary judgment are granted in their entirety. Brownells, Russell Fagan, and Sinistral Shooting Technologies are terminated as parties. So terminated sounds like bad things, but this is entirely good for all of those people. They are super happy because if you are being sued and you are terminated as a party in the lawsuit, it means you win. You're free. So all of those people get to walk away from GWACS without paying GWACS a dime. Fantastic. These are big winners. You know what I'm saying? We're going to divide up who's winners and who's losers in this. Brownells, Russell Fagan, Sinistral Shooting Technologies, all big winners. Sean Nealon, also a big winner. Plaintiff's motion for an order dismissing claims against Sean Nealon with prejudice is granted. It's not the way Sean Nealon wanted to get out of the lawsuit, but he's out of the lawsuit. And he was being sued. He doesn't have any counterclaims. So when Sean Nealon is terminated as a party, fantastic. He also goes in our big winner category. So it is further ordered that defendant KA Arms LLC's motion for summary judgment is granted in part and denied in part. So KA is not entirely out of this lawsuit. They are partially out of it. The claims are going to be cut down. So the motion is granted as to GWAC's claim for misappropriation of intellectual property, the 6th cause of action, and breach of the implied covenant of good faith and fair dealing, 7th cause of action. The motion is denied as to GWACS's claims of breach of contract, 1st cause of action, and misappropriation of trade secrets, 2nd cause of action. So there's only 2 causes of action left against KA. Still a winner, right? This is still, they're a winner. And it is further ordered that counterclaim defendant's motion for summary judgment and brief in support is granted in part and denied in part. So this is GWACS. The motion is granted as to KA's counterclaims of breach of the applied covenant of good faith and fair dealing. Of course, it was going to be once KA won on that one. Interference with prospective economic advantage, business disparagement and deceptive trade practices and unfair competition. The motion is denied as to KA's counterclaim for declaratory relief. Now that means that GWACS has actually gotten out of most of KA's counterclaims. And in fact, all of the counterclaims that would involve money. So at the end of the day, it doesn't look like GWACS is going to end up paying any money to KA. However, declaratory relief is that the court says, we declare that you're not in breach. And we're going to stamp this with our court stamp of approval. So that will still be a big win for KEA if they win on that. I say on balance, KEA is still a winner, but it's a lot closer, right? They're a small winner on this one, is how I phrase this, because they got some of what they wanted. They're still, and a lot of the claims against them were thrown out, but they didn't win everything they wanted to win. And a lot of the stuff that they wanted got tossed here. So small winners. They're ahead, but they're not as ahead as some of the other people. It is further ordered that defendant's motion for spoliation sanctions is denied, which we already covered. Like that, they kind of got a lot of what they wanted out of it anyway. It is further ordered that defendant Sean Nealon's motion for summary judgment is moot. I feel like the big losers on this one is GWACS, but GWACS did get a bunch of stuff out of this, right? A bunch of counterclaims against GWACS were thrown out. So everybody wins something. Some people lose a bunch of things, like GWACS and KEA both had places where they're in the win column and the lose column. Everyone other than those people just was in the win column. So this is real interesting, and it's cut this case right down to the essential bits. We have got this to the core of the case, and now we're going to get ready for the end game. This is where we'll either see a settlement or where we'll see... I kind of feel like these parties don't seem like they're getting along. I don't know if they're going to settle. I have some suspicion that maybe they won't. So... now the court strikes the pretrial conference set for March 1, 2023, which is a couple days ago, and the jury trial set for March 20th, 2023, so that the parties have the opportunity to finalize a proposed pretrial order reflecting these rulings. We're not going to run the trial while they're still hammering out the details. Final joint proposed pretrial order to be submitted no later than March 31st, 2023. That's the deadline for everybody to sit down and figure things out and go from there. The pretrial conference is reset for April 5th, 2023, and the jury trial, set for April 17th, 2023 at 9:15 a.m. I don't know if that's going to be the final day. Civil matters have their jury trials moved all the time. It's a thing that happens, but... we'll see. It is further ordered that this matter is set for an additional settlement conference between Magistrate Judge Christine Little on March 3rd, 2023 at 9:30 a.m. Hey, that's today. Settlement conference statements to be submitted. So, yeah, I don't know what's happened in that settlement conference. I don't think I'm going to find out because there's not many parties left. And, I'm not in touch with KEA Arms, so I don't know. Unless somebody puts out a statement, I will not find out what's going on there. All right. So, as mentioned, we've got some big winners in this, and we've got some smaller winners and some arguably losers. This is going to be an interesting case. We're going to have to see what shakes place, but a lot of people were sort of wondering what's going on in this one, and I really wanted to make this a proper deep dive. I hadn't done a deep dive in a while, and I feel like this case kind of deserves it. There's a lot going on. Just to understand what's going on, what's left in this case, and why is it left. A lot of the cases, or a lot of the sort of causes of action have just been annihilated, and a lot of that is based on GWACS's complete failure to have any intellectual property when they were claiming intellectual property. The downside to this, the real sad part of all of this, is that this means that this case will have gotten less funny. We've probably exhausted a lot of the really hilarious stuff in this case, which really makes me sad because this case has been a source of joy for me because it's just, every time I look at it, I go, really? Really? You're claiming IP and you didn't check that you have any? So those claims have been tossed because, as I've said from the beginning, I mean, I said early on that those claims looked stupid, and the court has agreed. They look real stupid. So, yeah. Before I go through and, do the Patreon shoutouts, and please like this video, share it with your friends, subscribe to see more content. If you want to support this channel via Patreon, there's a link in the description below. You can add your name to the list of shoutouts here. But one of my fans sent me something that is hilarious, and I want to share it with you. That is Granger's GWACS. It's a product, folks. So it's not what I imagined that GWACS might be. It's a different kind of GWACS. This apparently is for boots. It advertises that it waterproofs, conditions, and protects all full grain leather from water, oils, and stains. And there's directions as to how to apply it. If swallowed, get medical advice attention. I think that applies to both GWACS. So yeah, this is actually kind of useful because I do some leather work. So I'm going to use this, and I will feel really weird if I end up being a fan of GWACS, the leather care product, which, I mean, I like a beeswax protection thing. That's what this is. It uses natural beeswax. This, I should note here, this is not paid product placement. Somebody just sent this to me, and it's funny. But yeah, so here's a GWACS already on the market. I'm kind of saddened that it's not like a personal product. Anyway, as I said, thank you guys for watching. Please like this video, share it with your friends, subscribe to see more content. I want to thank my Patreon supporters at the $50 level: CCFR, David Michaud, Canada's National Farms Association, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited, J-Babe and Luxor. And at the $20 level, Lindsay Metcalf, Kyle Fox, Haywire, Gerald to the Bailey, Cameron Johnson, Andrew Elsich, and Vicky. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you guys for watching. I hope this has armed you with knowledge. I hope you enjoyed this deep dive into this case. The next step may well, or the next step that I cover may well be the trial itself. I don't know if they're going to televise it. That'd be real nice. I got to figure out what I'm doing with this because it's going to be interesting. Anyway, thank you for watching. See you next time.